Good morning or afternoon. It's noon, so good afternoon. But let's be real, the majority of us are probably at home watching this in our pajamas. Keeping it classy, keeping it true. I didn't want to give you guys too terribly much this week because I put up about, got like 3 or 4 crash course videos because I think they're amazing and don't fix what's not broken. But I also want to draw your attention to something amazing that I did. That white thing, that's an IKEA dresser, and I put it together by myself. I only sustained this one injury. So basically, I'm a genius, and if anybody needs anything from IKEA put together, it's like high stakes Legos. Yay! Shall we begin talking about civil liberties? So one thing that I want to bring your attention to is the difference between civil rights and civil liberties. And the crash course videos that I put up on Blackboard on top of this really do a much better job of exemplifying this, especially if you're somebody who has to hear it in order to quite understand. But civil liberties are going to be protections from the government, improper governmental action, right? We have the first 10 amendments, erroneously called the Bill of Rights, when in fact they're actually a Bill of Liberties because they are laws that prevent government from doing something. They're negative freedoms, and I say negative, I don't mean bad, I mean less. So government cannot act on these particular things. Civil rights, on the other hand, require that government actively do something in order to protect a larger group or a disenfranchised group to ensure that people are being treated equally, okay? And when you are looking at civil liberties, you can classify them in 2 ways, substantive and then procedural. Substantive are going to be limits on what the government can actually do in terms of what is written as law. So we see the Supreme Court of the United States yesterday decided on a pretty big civil liberties law in which they included LGBTQ communities as part of the Civil Rights Act of 1965, which means that up until yesterday, employers could terminate somebody's employment based on their sexual orientation, and that was actually written as law. So in this way, they have amended the substantive liberties to say that employers, the law writes that employers cannot terminate somebody based on their sexual orientation, their gender, their religion, age, other things like that. So that is a substantive liberty, which means that it is written in law that government cannot do this, or individuals cannot, businesses, that is, not individuals. So procedural restraints in the Bill of Rights are going to be how government must act, and you're going to see this largely with rights of criminally accused. Government has to provide due process of the law. Government has to provide you with an attorney if you cannot afford one yourself. Government has to follow certain steps that are there specifically to protect your individual rights. So let's move on to civil rights. Civil rights are going to be things that the government has to actively do something to protect, especially from minority populations. Things like voting, okay? Discrimination based on religion or sex, sexual orientation, etc. And all of this is pursuant to the 14th Amendment that says everybody is entitled to equal protection under the law. So, much like we saw in the previous lecture with federalism, that the federal government uses the Interstate Commerce Clause frequently to expand their power, people will argue that their rights are being infringed upon based on the 14th Amendment. An example of this is San Antonio versus Rodriguez. I'm not going to get into the specifics of this, but in that case, the state of Texas was being sued because of the way that their public school funding scheme worked. So a group of people, oh, you have to forgive me, I'm fiddling. You know, I'm a fiddler, so I have to have something in my hands. I'm peeling off an orange crown. So the state of Texas uses property tax schemes to fund their public education, which arguably, and I mean evidently, creates a very unfair funding scheme because you're going to see high property values in certain areas and low property values in other areas. So the case of San Antonio versus Rodriguez was one in which the parents in SAISD went to the United States Supreme Court and asked them to look at this funding scheme under Texas's law that said property taxes can be used to fund public schools, and they said it was unconstitutional pursuant to the Equal Protection Clause because they were not treating all Texas public school students equally. That didn't work out because the United States Constitution does not provide any kind of guarantee to an education. That's a state responsibility, which we would have mentioned last class with federalism. But in any event, that would be one of the examples used to pursue an expansion of civil rights under the 14th Amendment. Okay, so let's move on. A couple of cases that are exemplified, the reason that we have civil liberties is things like to protect unpopular minorities. An example of this would be Skokie, Illinois in 1977. Civil liberties are understood to be a check on the majority in order to allow even unpopular minorities to speak and act as they desire. So, regardless of your opinion, and you guys are all familiar with this, what I'm about to say now, regardless of your opinion, you still have the same liberty to express your speech or expression or religion in any other way that you would look. So the case of Skokie, Illinois in 1977 was an American neo-Nazi group that protested the government, petitioned the government to allow them a permit to protest in a largely Jewish community in Skokie, Illinois. This is obviously problematic because nobody likes neo-Nazis, but also this Jewish community was elderly and largely survivors of the Holocaust. So as much fun as it is, oh look, everyone, wave. It's my man's. So, yeah, no elderly person who had survived the Holocaust wants to see an American neo-Nazi group marching outside of their house. However, because we have these First Amendment protections and civil liberties in place to protect unpopular minorities, they enjoy the same protections that the popular minorities would be, and they were granted their right to petition. I had to stop the camera to tell my husband that he's going to be on camera. And he said he doesn't care. Can you please turn? Ugh, God, I don't know how to be creepy about it. Alright, so we have talked about the history of the Bill of Rights, so I'm not going to spend too much time on that, but you know that there were supporters of the Bill of Rights, which largely included the Anti-Federalists, because they felt that the Constitution without a Bill of Rights didn't go far enough to extend or protect individual liberties and rights. The critics were the Federalists because they felt it was an unnecessary hurdle for the government to have to go forth if they wanted to create any kind of laws. So it also was challenging because states felt as though an incorporation of the Bill of Rights would take away from their state autonomy. Currently, you're going to see this as a similar argument to federalism right now, especially when certain states want to do things like ban same-sex marriage or require a certain kind of insurance or lack of insurance, things like that. Or perhaps they want to reopen the state or keep the state closed because of, I don't know, an infectious disease. In any event, we do know that it was passed, ratified, and incorporated into our Constitution. So I'm not going to spend too much time talking about freedom of religion because there's a gentleman named Craig on Crash Course that does a phenomenal job of it, but I do want to bring your attention to a couple of things that he may not hit on as hard as I will, and it will be on your quiz. So, First Amendment reads as follows. Actually, the first half of the First Amendment, because the First Amendment actually protects 6 things. Free establishment, free exercise, free speech, free assembly, free petition, and there's one more, but I can't remember it right now. Bob, do you know?
No.
He doesn't know. In any event, so the first case we're going to look at is the landmark case is called Lemon v. Kurtzman. I'm actually going to click this button, and it's going to take you to this case, Oyez. Oyez. Lemon v. Kurtzman, I will read you the facts of the case and the question and explain the conclusion. So in this case, they are looking simply at the idea of taxes being provided to private religious institutions, like a private Catholic school, a private Christian school in Rhode Island and Pennsylvania. Pennsylvania had a statute that provided these public funds to the private religious institution to pay for salaries of the teachers, textbooks, and instructional material for secular subjects like math or English, things like that. Rhode Island statute was passed the next year and provided financial support, supplementing, 15% of the salaries, and that's it. So they're asking the question is, can the state fund private religious schools? Does that violate the Establishment Clause of the First Amendment, which says that no, the government cannot impose or prevent a particular religion upon the people. Let me see if I can figure out how to make this bigger again. So, the Establishment Clause is the first half of the First Amendment, preventing the government from respecting an establishment of religion or preventing the government from prohibiting the exercise of that. So if we're looking specifically at the first part of that, Congress shall make no law respecting an establishment of religion. This means they cannot prevent somebody from enjoying whatever religious practice they choose, and they also cannot promote one over another, okay? So, going back to Lemon v. Kurtzman, can the state of Rhode Island and Pennsylvania fund these private religious schools? Does that violate the Establishment Clause? Bob, what do you think? Oh, he wasn't listening. That's not a good student. The answer to your question is more, it's larger. The answer is yes, they can, but here's why. Click. This is a landmark case because it gave the government a way to decide whether or not a regulation or law was going to violate the First Amendment. It's called the Lemon Test. The Lemon Test is three-pronged. It asks, does the government involvement have a secular or non-religious purpose? So if the government is funding textbooks that are secular or non-religious, salaries, instructional materials, is that religious in purpose? No. Is the effect of that policy or regulation advancing or inhibiting a particular religion? In this case, it is not advancing any particular religion, nor is it prohibiting or restricting a religion. And so the answer there is no. And then finally, which is no longer active, it's kind of been more incorporated into the first two, is does it entangle government and religious institutions in each other's affairs? In this case, again, you're going to say no, it doesn't. So in this case, if you answer no to all three, that regulation or policy cannot be considered to be an infringement on somebody's First Amendment right to free exercise or establishment. Okay? I want to look at Sherbert Werner real quick, and then we're going to skip the third one and go into the Church of Babaluai, because I think Bob will be interested in it. So, in this case, Sherbert was a Seventh-day Adventist, and he was fired, and by the way, he is a she, it's a woman, Adele, was fired from her job after she refused to work on a Saturday. The Employment Commission said that she could not get unemployment because her refusal to work on a Saturday constituted a failure without good cause to accept available work. The question we're looking at is not whether or not she should have been terminated. The question we are looking at is whether or not the government can refuse to grant her unemployment because of her religious refusal to work on a Saturday. I'll give everybody an opportunity, including Bob. Does he have any idea? He wasn't paying attention again. Does the denial of unemployment compensation violate the First and 14th Amendment? And in this case, The free exercise clause prohibits the government from setting unemployment benefits, okay, such that a person cannot properly observe key religious principles. And so in this case, no, they cannot. The court held that the state's eligibility restriction for unemployment imposed a burden on Sherbert's ability to freely exercise her faith, and there was no compelling state interest to justify it. Okay? So again, want to check my office hours. It's not that whether or not she should have been terminated. It is the fact that, I wonder how I do this. The state refused her the ability to get unemployment. I really want to fix this, but I don't know how. Fixed it. Okay, so finally, this one I would like for Bob to take a second and pay attention to it, if you wouldn't mind. He begrudgingly accepted. Okay, so here are the facts of this case. The Church of Lukumi Babaluai practiced the Afro-Caribbean-based religion of Santeria. Raise your hand if that's reminding you of the song by the Red Hot Chili Peppers.
That's not Red Hot.
Who is it?
That's Sublime.
Oh my God, it's Sublime. Raise your hand if it reminds you of the song by Sublime. And obviously to Bob it does. Santeria used animal sacrifice as a form of worship in which an animal's carotid artery would be cut, and except during healing and death rites, the animal would then be eaten. Shortly after the announcement of the establishment of the Santerian Church in Hialeah, Florida, the City Council adopted ordinances addressing religious sacrifice, in particular banning the possession of animals for slaughter, with the exception of state-licensed activities. Did the City of Hialeah's ordinances prohibiting ritualistic animal sacrifice violate the First Amendment of the Free Exercise Clause? Bob?
I know my rights. What?
Bob just yelled, "I know my rights." This is what I'm working with. Bob, what do you think?
I say yes.
Bob says that the ordinances do prohibit ritualistic animal sacrifice. Do inhibit free exercise because it prohibits ritualistic animal sacrifice. Is that correct, Bob?
Yeah.
Bob's right.
I know my rights.
And then he yelled, "I know my rights" again. So, in this case, Bob is correct. Congratulations, Bob! Yes, the court held that the ordinances were not neutral nor generally applicable, and so it failed the Lemon test. Okay? Answer these three questions. Does government involvement have a secular purpose? Does it neither advance nor inhibit a religion? And does it entangle each other in affairs? If they answer no, you passed. And Bob knows his rights. I love him so much. Alright, so let me figure out how I did this last time. Boom. Okay, move on. Okay, so I have a whole section on Crash Course dedicated to freedom of speech, press, and the assembly. So I'm going to go ahead and move forward with this one. And I believe they also talk about the Texas v. Johnson case, which gave a standard of strict scrutiny to government regulations, meaning that if the government wanted to impose a restriction on your free speech or assembly, the government is required to answer the following three. Is it a compelling state interest? Is the regulation narrowly tailored using the least restrictive means to impose that? And in this case, the Texas v. Johnson was unable to adequately do that in a way that would not infringe on their right to free speech. And the free speech we're talking about here is, do you know, Bob? Flag burning. Can you burn a flag as a matter of freedom of expression? Bob?
If you're a douchebag.
He says if you're a douchebag. And I guess the answer is yes. And if you want to get on Bob's bad side.
Burn the flag.
And so there are still restrictions. You cannot do anything in the name of your free speech or establishment or assembly. You still have some things. Oh my God. Oh, it's my dog Layla. She just licked me. It scared me. So, what can be regulated by the government? There are strong protections rights, but how you exercise those rights can still be regulated. For example, you cannot impede traffic, you cannot infringe on the right of others, which I know are very ambiguous, they're very vague, it's hard to say what that means, and that is kind of the nature of the game with civil liberties. What we know that they can't regulate is the speech based on its content. Government can't say, well, I'm not going to give you a permit to have a petition or rally or whatever you want to because I don't like the content of your message. Okay? The regulation has to be unrelated to the ideas and the views expressed. Okay? However, the speech or action cannot cause an immediate breach of the peace. And the one that I like to say or give an example of is, how is the speech going to, what is the reaction that you are soliciting from that speech? Is it going to cause some sort of immediate situation? So if, for example, Bob is unhinged a lot of the time, right? Look at him right now.
True.
So if he's in a classroom, if we're all in the classroom together and somebody runs down the hall screaming shooter, what is the solicited reaction? What does that person want to do? Does that person want us to peacefully gather outside and see what he's doing, or does he, want us to go crazy? If you have somebody like Bob in the room, there's a very good chance that things are going to go bad pretty quickly. He wants me to stop talking to him.
With the microphone.
So, in that way, the government can hold you accountable for your speech. Here is another example of one opportunity for the government to regulate speech. It's called prior restraint. It's extremely difficult to use, but it is the prevention of material from being published prior to its exposure. The government cannot prevent print media from publishing what it desires with certain exceptions. For example, if it is an issue of national security. So if there's perhaps an example of, can the press, if they find the coordinates of a highly classified tanker or submarine outside in enemy territory for a co-op operation, it would be a matter of national security for them to publish the coordinates of that, right? However, the government cannot say, well, I don't like you having this information. It's been leaked, it's classified, and it does not look good for us, so let's just go ahead and use prior restraint. Whoops. In this case, you can know that the Pentagon Papers would be an example of that. The Pentagon Papers were during the Vietnam era and were classified material that got leaked out to the general public, especially to the media, Washington Post and New York Times. And it really painted the United States in bad light with regards to Vietnam. And the United States government attempted to use prior restraint to prevent the publication of that material. However, the Supreme Court looked at it and said, just because it's going to make the United States look bad doesn't provide any kind of real exclusion on its ability to be published. And so in that way, it's extremely difficult for the federal government to impose prior restraint, but it is one of the exceptions. They do have that ability if they can argue that it's a matter of national security. Okay, moving forward. This is Hustler magazine. Apparently, y'all are too young for the most part to remember what Hustler magazine is, but I can tell you it was the very trashy pornographic magazine. And you guys might be familiar with like Playboy or Maxim or whatever. This is not classy material, okay? This is bad stuff. This is like your lowbrow kind of real perverted stuff. At one point, this guy, Jerry Falwell, not Jerry Falwell. What was his name? Larry Flint. Larry Flint was the editor, CEO of Hustler magazine, and at one point he put on the cover a picture of a naked woman falling into a meat grinder. Classy stuff. He has a celebrity feud with evangelical political activist named Jerry Falwell. Jerry Falwell was the Joel Osteen of the 80s. And in Hustler magazine, Larry Flint put a parody of a Campari ad featuring Jerry Falwell, and in which he discussed in which Jerry Falwell discussed losing his virginity in an incestuous, drunken outhouse relationship with his mother. So, and Falwell then sued Hustler magazine and Larry Flint for emotional distress. It went back and forth a couple of times, but the end result of this actually landed in favor of Larry Flint. That this was so outrageous of a claim, it couldn't be something that would inflict emotional distress on a celebrity, because a public figure necessarily takes, you've got to have a little bit of thick skin if you're going to be in the limelight. And so in this case, in terms of slander and libel, I'm going to go back a slide. Maybe, if I can figure out how to. Slander and libel. Jerry Falwell attempted to sue for emotional distress, slander, and libel, negligently publishing a lie that harms a public figure in particular. And in this case, the Supreme Court said it was so outrageous and so stupid that no normal person would consider it to be true, especially the contents of the magazine itself. You know, they said part of being a public figure is having people not like you and publish things that are maybe inaccurate. But unless you can have some demonstrable proof that it caused you some harm that you can show, palpable, tangible harm, you know, it is what it is, which is why everybody puts whatever they want about Trump up, and for the most part, it's fine. There's nothing he could do about it except tweet. This is my Elvis coffee, by the way. I love Elvis. Okay, so fighting words and hate speech are going to be things, again, that are not protected, but they're very difficult to ban or regulate, because people always have the ability to ignore the fighting words or the hate speech, okay? When the words leave the realm of thought and move into direct and immediate action, the speaker can be held accountable. I can say, I really, really wish that somebody would go over to my neighbor's house and kill his peacock, because we have somebody, our backyard neighbor has 2 peacocks, and they're very, very loud, like all the time. I would love it if somebody took care of it, but that's not, it's just realm of thought. Now, if I said, I am going to go over there and kill the peacocks, I could be held accountable. Why would anyone want to kill those peacocks? I don't know. Maybe they're trying to make some feather boots. Bong hits for Jesus. I really like to talk about this one because most of you guys, some of you guys are coming from high school, and this kid is coming, he's in an Alaskan high school, public high school, and he goes to a off-campus school-sponsored event holding up this sign that says Bong hits for Jesus, and he is suspended. And he's saying he is fighting his suspension based on the idea that Bong hits for Jesus is, oh no, hold on, I just got one of my family members just tested positive. That was anticlimactic. My mom texted me that one of her friend's daughters came up COVID positive because she likes to gossip. In any event, Bong hits for Jesus at a school-sponsored event, saying that a suspension based on the content of this message would be an unlawful infringement on his First Amendment freedom of speech. So let me ask you guys, if you were in high school and you held up a sign that said Bong hits for Jesus at a school-sponsored off-campus event, what would happen? I'll give you a moment to think about it. Yeah, you'd all be suspended too. And the Supreme Court agreed, saying that while students do enjoy some First Amendment rights as students, that does not extend to advocate for the very important anti-drug message that they're trying to advocate during school. So Bong hits for Jesus is a no-go. Students don't have as much say as they'd like. Let's talk about porn. I really wish Bob was here for this one. He would love it. Pornography cannot be regulated, not because people, what is pornography, but mostly because you can't define it. What is obscenities? You can try and regulate obscenities, but then you have to try and prove what you're regulating is actually obscene. Okay? Now, what we find obscene here in San Antonio can be geographically variant. For example, if we go to Austin, things are weird up there. Go down to Houston or another area of Texas, it might have a different standard, okay? And so you can't have a unilateral message against obscenities because obscenities is difficult to define. In fact, when trying to define obscenities, Supreme Court Justice Potter Stewart said, "I'll know it when I see it." What is that? That's a dirty pervert for sure. You can ban child pornography, obviously, and I don't think there's anybody I've ever encountered that finds the banning of child pornography an infringement on anybody's right to do whatever they want unless they have some serious questionable habits. So harmful to children, it involves several crimes, but in this case, pornography or obscenities cannot be regulated because it's too difficult to define. Commercial speech does not have the political speech protection, political speech being the most highly protected once you kind of go down from there. Commercial speech really only needs to have a rational reason to ban an advertisement, and in fact, you could usually go see these banned commercials easily on YouTube. But because the FCC only regulates broadcast-based media, which would be your the kind of things that you could subscribe, you don't have to subscribe to channels that you will show something for free. You could just plug in your TV to regular old box and you'll have access to these like CBS, NBC, ABC, Fox. So in this case, they have a lot more leeway to ban commercial speech as long as they have a rational reason. I am not going to spend time talking about the Second Amendment, but I will put all of these links here and rights for the criminally accused. At the same time, I'm going to skip forward on those, but I do want to talk to you guys about the Ninth Amendment because nobody ever talks about the Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. If, through the course of human events, another right shows up, perhaps the right to privacy, the right to say something online, that can be included. They added the Ninth Amendment specifically so that nobody would think that the 10 rights listed in the Bill of Rights, these 10 amendments, are the only rights that we have. If there are more rights that present themselves throughout times, those belong to the people. And that's extremely important because you'll see that some of these unenumerated rights that we just talked about, rights that are outside of the ones specifically expressed in the Bill of Rights, have presented themselves, right? You have the right to do what you want in the privacy of your own home. And so you've seen a lot of things argued under this, specifically here. Birth control, abortion, homosexuality, the right to die. Do you have the right for physician-assisted suicide if you're terminally ill, or even if you're not? So these are just some of the ones that have been protected under the Ninth Amendment's rights. All right, you cool cats and kittens. That's it. So watch those crash courses. They're extremely helpful, sometimes more so than I am. Go through the PowerPoints. I don't think I had any other questions that were popular. Don't forget on the 20th, which is next Saturday, this coming up Saturday, is your current event. That's going to be due. You're welcome to turn it in early. I think that should be it. Please feel free to email me if you have any questions. I am in office hours every Tuesday, Thursday from 11 to 12:30. Come by. I'm just kind of sitting here by myself, alone. All right. Have a great day.